I'm Sean Aylmer, and this is Fear and Greed's Sunday feature interview. I'll be back again tomorrow with another weekday episode of Fear and Greed, the normal mix of business news and interviews that sets you up for a successful day. In the meantime, enjoy our Sunday feature interview. At Fear and Greed, we call on business practitioners and experts for their perspective on events and advice. Today, we're talking to an expert on labour law about the impact of the gig economy. The gig economy is also known as the on-demand economy and describes use of technology to match people with work that needs to be done. High-profile examples include Uber, Airtasker and Expert 360, and there are many, many more. It's become a very big part of how we live and how we work. We're using more and more apps to go online, to get food delivered, to pick up a ride somewhere, book somewhere to stay, maintain the garden, that type of thing. The rise of the on-demand economy creates all sorts of challenges around pay, around occupation and work, safety issues, labour laws, protection for employees. Anthony Forsyth is Professor of Business at the Graduate School of Business and Law at RMIT University. He's also the publisher of the blog labourlawdownunder.com.au. Professor Anthony Forsyth, welcome to Fear and Greed.
Great to be with you. Thanks for having me.
Now tell me, on-demand work's got a lot of appeal. You sign up to an app, you look for work or a job that you want to do or get done. There's all sorts of challenges in that. When I've done it previously, when I've been looking for people or when I've been offering my services, actually finding a price is really difficult. Kind of understanding where you are in the pecking order, that type of thing. How do you get your head around the gig economy and how you ask for services or offer yourself to do services? Can you give us a bit of a 101 on it?
Well, I view all of this from the perspective of an academic expert in labour law who worries about the implications of the gig economy for our system of labour regulation and the traditional protections that we've enjoyed in Australia for workers for a very long time. I think there are a lot of workers who come to the gig economy, platforms like Uber and Deliveroo that you mentioned, Fedora, which operated for quite a while in Australia before leaving a couple of years ago with a few problems attached to it, which we might come back to later. But I think workers come to it not really expecting to be able to bargain that much or have much of a dialogue over what the terms and conditions would be. And that's because predominantly the platforms determine from the outset what the rates will be, and more importantly, the manner of engagement of these workers. And the way they've done that is to really flip our traditional assumption about how work is regulated in Australia. Traditionally, we've attached labour law protections under awards, say the Transport Award for people doing food delivery work, and we've said that people should be subject to those protections if they're an employee. And we use a common law test to determine who's an employee and who, on the other hand, is an independent contractor. And generally, we've considered independent contractors to be people who are undertaking entrepreneurial activity, running a business of their own. What most of these platforms have done, both here in Australia and overseas, is to turn that upside down and say, we're engaging everybody as a contractor, regardless of the type of work they're performing. It might be, driving for Uber or delivering for Uber Eats. And it's up to you, the worker, to take us to court to disprove that you're a contractor and therefore establish that you're an employee who is deserving of those traditional protections around awards, around health and safety, around workers' compensation and superannuation.
Those protections, which are the key ones? I'd imagine OH&S and superannuation are both very significant.
Absolutely. I mean, workplace safety clearly has become an even more significant issue in the time of the pandemic. And, a lot of challenges for people doing food delivery work for Uber Eats or for Fedora or for DoorDash, who are now operating in Australia, around doing that work safely. So if there's uncertainty about whether the business you're working for has any obligation to accord safety protections to ensure that you can do that work with as minimal risk of infection from COVID-19 as possible, you don't want any of that uncertainty. But that's what's been created through the way in which these platforms have structured their business operations and the way in which they engage people. Another major area would be whether or not a worker doing food delivery work, for example, is covered by an award, because that would set the minimum wage that they can expect to be paid for doing that kind of work with an hourly rate, an additional rate if it's casual, further additional rates if it's, overtime or on weekends. Instead of that, what most of the platforms do is have rate structures that are built around, it might have some component of a flat rate based on the tasks performed, but they have also changed their rate arrangements, platforms like Deliveroo, when there has been a sense that the regulatory system might be catching up with them to some degree. That's happened more overseas than here in Australia. But, in all of these areas, there can be great uncertainty for workers about what they're entitled to because they're not classed as employees by the platforms.
So the platform's model, obviously they're saving a lot of on costs. Do you have a sense of how much on costs add to a traditional employee-employer relationship? I suppose I'm trying to get a sense of what the delivery person is missing out on, in a sense, by valuing those on costs that a traditional relationship would have.
Well, it probably varies, obviously, depending on the different platforms that we're talking about. But, if you take rideshare drivers, they'll be paid a certain rate by Uber or by one of the other operators. It'll only be a component of the true rate that they would be entitled to if they were classified under an award as an employee who was entitled to those other types of payments that I mentioned in addition to the hourly rates. So I think I can't put a dollar figure on it for you that would sort of carry across all the different types of platform work. But I think what you're getting at is definitely what gig economy platforms have had in mind globally when they have come out with these arrangements. And I think part and parcel of the way they've done this and the sort of narrative that they've spun around it is that this is innovation, this is startups, this is exciting, flexible forms of work that people should be attracted to because they can do a bit here and a bit there, and they don't have to be worried about a minimum engagement of 2 hours if they're a casual under an award. So I think they've sort of hooked a lot of people into the idea of this being a flexible and an entrepreneurial way of performing work. But the evidence increasingly is showing us that for workers, it's not a great value proposition.
Shouldn't we let the market work that out? If people aren't getting recompensed for what the effort they're putting in, and that's a sort of like a total package value there, which includes superannuation and insurance and that, won't they leave the market then?
Well, I think you're asking a question that goes to the essence of why do we have labour regulation at all? Why has a country like Australia had traditionally a stronger framework of labour law protection, including awards that have been around for over 100 years? And I think it's because we've always taken a position, and it was tested during the work choices period under the Howard government, so we had a little interruption. But I think generally in Australia, we've taken the view that we value fairness in the labour market and we value things like job security. And so if you want to compare it to a country that doesn't value those things, let's talk about the United States, where it's a shocking outcome for workers, including many workers in the gig economy. So even as a waged and salary worker in the United States, you could be working multiple jobs just to get by because there's no minimum safety net that's decent compared to what we have in Australia. So I think, sure, to some extent, the market works this out. But I think particularly now in what will hopefully at some point before too long be the post-pandemic period, where there's a lot of unemployment, where jobs are scarce, I think the driver is going to be that, or the narrative from business and perhaps from the coalition government federally will be people should just settle for whatever the market offers them. And I don't think in a country like Australia we should settle for that, and particularly not in relation to the gig economy.
Add COVID-19 to that, where you've got millions of people unemployed or underemployed. There's not going to be a lot of pressure to push wages up and to implement some of these conditions.
No, I think we can see already in the debate that we're entering into now in Australia around workplace issues because of COVID-19 and its long-lasting economic impact that we're looking at. We can see already that the pressure is very much going to be the other way. So we at the moment have a federal government industrial relations task force where unions and business are looking at reform issues, but the gig economy is not even on the agenda in that discussion. That discussion is about casual work. It's about whether awards are too restrictive, as many business groups argue. It's about why is enterprise bargaining broken and very little activity is occurring in negotiating new agreements. So I agree with you. I think at the moment, because of the impact economically and the massive loss of jobs from the pandemic and how we're going to rebuild the economy, the current of debate is very much away from our traditional system of regulation and protection.
How big is the gig economy in Australia?
Well, it hasn't been completely accurately measured. So part of the thing that initiated this discussion between us is the recent Victorian government inquiry, which is, I understand, the world's first government full-scale inquiry into the gig economy. Its report last month, after a 12 to 18-month investigation, indicated they commissioned a number of academics, not me, but some others around Australia, to do some assessment. They did a large-scale national survey over the last year or so and found that around 7% of respondents to that survey, 7 or 8%, told them that they were currently working in the gig economy, and something like 13 to 14% of respondents had done some work in the gig economy in the last few years. So there's a lot of people out there doing it. We know it's growing. It'd be in the hundreds of thousands of workers who are engaged through one or other of the platforms or apps. But we definitely know from the survey evidence that that number is increasing.
I understand the platforms probably don't have a huge incentive to raise this issue, but certainly unions would, and the federal government should. Why do you think we are so far behind? As you said, it's not even on the IR reform agenda.
Well, I think it's a product of a number of things. So it did feature as part of the ACTU's Change the Rules campaign, which was a broader campaign about reforms that the union movement thought were needed to labour laws in the run-up to the last election. There was some component of that looked at whether we need to rejig the statutory tests or what are now the common law tests, but make it a statutory test for working out who is an employee and who is an independent contractor to address some of these concerns about the gig economy. Some unions have been very active in trying to challenge this business model that I've described about how platforms engage everyone as a contractor. So the Transport Workers Union, for example, has been working really hard on trying to assist its members and other workers engaged by the rideshare platforms and in food delivery. The Young Workers Centre at Victorian Trades Hall has also been doing a lot of that work. So I think there's plenty of room for other unions to get in there, but that's also one of the challenges, because part of the consequence of calling everyone a contractor is if you're classified as an independent contractor under Australian law, you're not actually allowed to collectively bargain. You don't have access to the Fair Work Act to do that, and you're restricted from doing it by competition law as well. So you can't win.
You've certainly called for a common definition of employment across the Fair Work Act and other laws. The report that came out in June, the Victorian Premier and Cabinet report, did that have any recommendations that might actually be pushing us a little bit closer? Because undoubtedly this issue will become bigger and bigger as the gig economy becomes bigger and bigger. And even if platforms aren't thinking about it now, they're going to have to think about it. Where are the solutions?
So the Victorian On-Demand Inquiry, which was run by Natalie James, was the chair. She used to be the Fair Work Ombudsman and is now a partner at Deloitte. She did the inquiry for the Vic government, and she made some really interesting and important reform recommendations. So one of them was, rather than letting this be a common law test where we case by case work out, or the courts work out, who is an employee, who is an independent contractor, and we have indicia that tell us one way or the other. What she recommended was that we have a statutory definition in the Fair Work Act that helps us determine work status, so whether someone is an employee or a contractor, and that test really needs to be based around either you're an employee, you're working for somebody else's business or undertaking, or you're a genuine entrepreneur. You're self-employed, you're running an autonomous business, providing services to another party under commercial arrangements. That means you're an independent contractor. If that test was applied, then many people working in the gig economy would automatically be classified as employees and have a lot of the employment protections that I've been talking about. Another thing linked to that she recommended was don't make it the obligation of the worker to sort this out by bringing an action in the court. The platforms should have to have this issue tested at the outset. And she recommended that an agency like VCAT in the Victorian system, Victorian Civil and Administrative Tribunal, or the Federal Circuit Court would have the role of establishing this upfront. So I think they're important recommendations.
What's the reaction been to those?
Well, I would say the answer to that is really caught up in the answer to the bigger question, what's been the reaction to the report more generally? And I think the short answer is the report pretty much got lost to a large degree in what's been going on in Melbourne in particular, in Victoria, with the resurgence of COVID. It's a great shame, actually, because I think in another circumstance, this report would have got a lot more attention. I think the Victorian government said it would examine the recommendations. But the other catch with all this is that the things that Natalie James has recommended are not things that the Victorian government can do anyway. They are matters that need to be dealt with under federal law. And I don't know that the federal government even responded or reacted to the Victorian report. I didn't see anything indicating that they had. But as I said earlier, they've shown very little interest at any point in time in addressing a lot of the concerns that have been raised about the position of workers in the gig economy.
It certainly is a very, very interesting topic, and one that I think will get a lot more airplay, and probably would have got a lot more airplay if it wasn't for COVID-19. Anthony Forsyth, thanks for talking to Fear and Greed.
It's been a pleasure. Thanks for having me.
Anthony is Professor of Business at the Graduate School of Business and Law at RMIT University. He's also the publisher of blog laborlawdownunder.com.au.